communication from the chair.
Honourable members, welcome you to this morning's sitting. Just two issues to communicate. One is that we should try as much as possible to run through the items on the order paper. Secondly, to ask the clerk to remind the ministers who have questions to answer this week so they can come and respond to them, the issues we need to have before the parliament closes. Thank you. Let's go to item 3.
Item 3 on the order paper, statement by ministers. 1 on the laying of the host government agreement, tariff and transportation agreement, and shareholders agreement for the East African crude oil pipeline.
Is the minister here? No? Okay, next item. But I hope she'll be able to come and brief us before we close.
Statement by minister on the implementation strategy of the proposed parish model.
Minister of Finance.
Thank you very much, Madam Speaker and colleagues. You recall the last time we were here, we agreed that on the request of the Prime Minister, we agreed that we should have an interaction with the Committee of Budget. Madam Speaker, we had a meeting on Friday with the Committee of Budget, and we generated consensus and a common ground on how to move forward. But in principle, as you guided, we are moving forward to implement the parish model to ensure that we reach the grassroots. And also we agreed on a number of ways on how this is going to be financed. And the Committee of Budget will be reporting the details of the financing. But in principle, we agreed that the parish model to targeting the 2 out of 5 households who live in subsistence economy should move forward beginning next financial year. The activities that will carry out, including recruitment of the parish chiefs, including training of the parish development committees in the first quarter, then beginning with the second quarter, the program and this strategy implementation starts in earnest. So the details of the financing, the Committee of Budget will be reporting on them, Madam Speaker.
Thank you very much, the Minister. So, honourable members, we shall wait to hear from the Budget Committee. Let's go to item 3.3.
Item 3.3, statement by Minister on the modalities for effecting the merger of selected government agencies, given that most of them are established by acts of Parliament.
Minister of Public Service.
Right, Honorable Speaker and colleagues, I wish to report that our Cabinet in 22nd of February 2021 approved the recommendations for the rationalization of government agencies, commissions, authorities, expenditure, and a roadmap for the implementation process for a period of 2 years to facilitate efficient and effective service delivery. The overall objective of rationalization of agencies and public expenditure was to eliminate structural ambiguities, functional duplications, and overlaps, wasteful expenditures, and realize resultant short-term and long-term savings, which would be utilized to provide other critical public services in line with the approved implementation roadmap. Right Honorable Speaker and members, my ministry was directed to report the House in regard to modalities for effecting the merger of selected government agencies, given that most of them are established under the Constitution or by acts of Parliament. I wish to report as follows. By way of a historical perspective, the Constitution of the Republic of Uganda 1995, as amended in 2006, in Article 189 and 6 Schedule and Section 9 of the Local Government Act Cap 243, clearly prescribes functions and services which were reserved for central government ministries. And these include policy formulation, coordination, inspection, provision of technical advice, and support, supervision, and training within the respective sectors of government. The Constitution further creates a number of commissions, authorities, boards, and other statutory bodies to support sector ministries to adequately fulfill their mandates. The creation of government agencies picked momentum in the early 2000s and continued to gain support due to the following reasons. One was obligations arising from international protocol agreements, international protocols and agreements, and two was coordination, conditionalities for accessing development assistance from development partners, and the other was the need to pay special attention to highly specialized functions and harness the necessary skills for improved efficiency and effectiveness for public service. However, in 2015, government of Uganda passed a resolution to freeze further creation of agencies, commissions, and authorities because it was realized that their continuous creation had not realized the original intended objective. Agitation had become an opportunity for different sectors to create additional institutions for selfish interests rather than the original intention. Among those interests were the anticipation of better terms and conditions of employment as opposed to the traditional or mainstream civil service, and lobbying for more resources at institutional level, which was more beneficial to those in the institutions. In view of the above, in 2016, Cabinet directed the Ministry of Public Service to undertake a comprehensive exercise on rationalization of government agencies, commissions, authorities, and public expenditure with a view of streamlining mandates, roles, and functions of these ministries, departments, and agencies. Also to in eliminating duplications and overlaps, and then assessing the relevancy of some of the existing government agencies and government expenditure. In addition, His Excellency the President had sanctioned, in addition, His Excellency the President of the Republic of Uganda raised a number of concerns on the several mushrooming agencies and demanded for clear practical recommendations to realize public institutions and ensure efficiency of government. It's against this background that the Ministry of Public Service embarked on an exercise to rationalize government agencies, commissions, authorities, and public expenditure as a means to improve service delivery. By way of problem analysis, in 1995, the Constitution of Uganda, as amended, provides for a definite number of agencies, that is commissions, authorities, boards, local councils, and other statutory bodies. There was a pilferage of frameworks such as statutes, acts of parliament, executive orders, and administrative arrangements, leading to the establishment of a multitude of public agencies without consideration of the institutional harmony and affordability. This mushrooming of government agencies has continued to create functional overlaps, as already mentioned, and duplications, jurisdictional ambiguities, drain the national treasury at the expense of effective service delivery, outstretch the capacity of government, sustain public institutions, salary disparities between agencies, employees and traditional civil servants, leading to wastage of resources, which would otherwise be committed providing critical public services such as health, education, and infrastructure development, among others. Therefore, implementation of recommendations on the rationalization of agencies, commissions, and public expenditure is a strategy to address the ambiguities. By way of scope, the exercise will require a critical study, analysis of the mandates, roles, and functions, workload, and structures of 18 government ministries and offices and 97 agencies, with a view of effecting mergers, mainstreaming, functional transfers to support improved service delivery. In this case, the word agencies is used to refer to the public entities such as government authorities, boards, commissions, and bureaus. The reform will also engage in the following: developing a change management strategy to facilitate smooth transition, undertaking job evaluation aimed at harmonization of pay across the service, and two, developing an administrative reform model for government of Uganda to coordinate public service reforms for the next 10 years. The objectives of the reform is to implement recommendations arising out of the rationalization of government agencies with a view of harmonizing mandates, functions, streamlining structural and operational ambiguities, eliminating the embedded duplications and overlaps, and determining the wage cost implications of the recommended structure. We have specific objectives which include implementing the approved recommendations of the review and rationalization of agencies and public expenditures, and which will entail studying, analyzing, and reviewing the functionality, operational systems, and structures of MDAs with specific reference to their mandates, roles, functions, and responsibilities. Also undertaking functional and workload analysis for MDAs with a view of determining optimal staffing levels and wage cost implications. And then the other one is reviewing the legal and policy framework within which government MDAs operate and make appropriate recommendation to support implementation. Then we have the second undertaking. The second is undertaking job evaluation to facilitate the design of a harmonized salary structure for the entire public service. And the third is identifying and re-engineering major dysfunctional operational and management systems in MDAs to facilitate improved service delivery. By way of roadmap, our Right Honorable Speaker, a cabinet subcommittee chaired by the Minister of Public Service has been established and is responsible for providing political oversight during the implementation process. And an interministerial technical committee has been constituted to coordinate the implementation of recommendations by cabinet. The secretariat has also been set up to coordinate the implementation process within these 2 years. Madam Speaker, I wish to report that the secretariat has also come up with a detailed implementation plan, which includes the first phase, this is 2021-2022, of implementation of recommendations on rationalization, which will focus on a comprehensive review of 18 government ministries and 97 beg your pardon. 97 agencies, yes, which are affected by the merger, mainstreaming, and transfer of functions. The second phase will be in the financial year 2022-2023, which will focus on the remaining 6 government offices and ministries and 61 agencies which were recommended for retention, but would require institutional review to enable them adequately respond to the current service delivery demands. Madam Speaker and members, during this period, the implications to the affected agencies are as follows. There is a freeze on the creation of new structures in the public service. There is freezing on new appointments and filling of vacant positions in the affected institutions. And the Ministry of Public Service will continue to guide on the transition process. Madam Speaker and members, I wish to report that the process will have legal, administrative, and financial implications, which include amending laws, especially for the agencies that were created by acts of parliament and those that are constitutional. And we propose to have an omnibus law and policy that will facilitate rationalization, and a compensation plan for the boarded off staff, a recruitment plan for the recommended structures, harmonized terms and conditions of service, a report on assets and liabilities for the affected entities, and an administrative reform model for the public service of Uganda for the next 10 years. And Madam Speaker and members, as I conclude, I wish to report that the projected resources to be freed are as a result of the implementation of the rationalization in the short term totals to UGX 988.12 billion, and the cost saving items considered include operational costs, including rent and entire development budgets. The projected cost savings are in form of freed savings due to the merger of some agencies and functions, as well as mainstreaming functions of some agencies back to their line ministries. Medium and long-term savings will be achieved when rationalization is fully implemented, and attached is the list of entities that will be affected and the legal framework plan of implementation for recommendations, implementation of recommendations on rationalization of agencies. I beg to submit.
Thank you very much, Honorable Minister of Public Service. Honorable members, this is just information about their plans. For now, there is no proposal for those actions. So the Committee on Public Service and Local Government is advised to remain seized of this matter so that they can brief us from time to time. Thank you very much. Item 4.
Item number 4 on the order paper, laying of the reports of the Auditor General on the financial statements for the year ended the 30th June 2020 for various entities.
Commissioner Muidike.
Where was it?
Honorable Speaker, I beg to lay a report of the Auditor General on the financial statements of the Uganda Prison Service for the year ended 30th June 2020. A report of the Auditor General on the financial statements of the Office of the Directorate of Public Prosecutions for the year ended 30th June 2020. A report of the Auditor General on the financial statements of the Office of the President for the year ended 30th June 2020. Report of the Auditor General on the financial statements of the Ministry of Justice and Constitutional Affairs for the year ended 30th June 2020. Report of the Auditor General on the financial statements of the Ministry of Foreign Affairs for the year ended 30th June 2020. Report of the Auditor General on the financial statements of the Ministry of Internal Affairs for the year ended 30th June 2020. Report of the Auditor General on the financial statements of the Office of the Prime Minister for the year ended 30th June 2020. Report of the Auditor General on the financial statements of the Ministry of Agriculture, Animal Industry and Fisheries for the year ended 30th June 2020. Report of the Auditor General on the financial statements of the Ministry of Local Government for the year ended 30th June 2020. Report of the Auditor General on the financial statements of the National Animal Genetic Resources Center and Data Bank for the year ended 30th June 2020. The report of the Auditor General on the financial statements of the Directorate of Government Analytical Laboratory for the year ended 30th June 2020. Report of the Auditor General on the financial statements of the Ministry of Defense and Veteran Affairs for the year ended 30th June 2020. And finally, Hoima Regional Referral Hospital Audit Report and Opinion for the year ended 30th June 2020. Madam Speaker, I beg to lay.
Thank you very much, Commissioner. Honourable members, all are sent to the Committee of Public Accounts, Central Government for perusal and report back. Item 5.
Item 5 on the order paper, bills, second reading, the Prevention and Prohibition of Human Sacrifice Bill 2020.
Honourable Batiku.
Thank you, Right Honorable Speaker. I beg to move that the bill entitled The Prevention and Prohibition of Human Sacrifice 2020 be read a second time.
Members, is the motion seconded? Seconded? Can you justify?
Thank you, Honorable Speaker, Right Honorable Speaker, and colleagues for supporting the motion. Madam Speaker, I stand here to justify the bill's second reading. Honorable members, on the 8th of April this year, I introduced in Parliament the Prevention and Prohibition of Human Sacrifice Bill 2020. The bill was referred to the Committee on Legal and Parliamentary Affairs pursuant to Rule 128 of the Rules of Procedure of Parliament for scrutiny and report back. Madam Speaker, the committee has finalized its scrutiny of the bill and is ready to report its findings to the House. Right Honorable members, Right Honorable Speaker and members, the object of this bill is to provide for the crime of human sacrifice, to provide for fines and penalties for the offense of human sacrifice and for related matters. Human sacrifice, Madam Speaker, has been a growing concern to law enforcement agencies in our country, parents, child rights activists, and the general public. Records from the Uganda Police Force show that human sacrifice cases have been steadily increasing for the last several years. Right Honorable Speaker and colleagues, human sacrifice targets the most vulnerable persons of society, such as children and persons with disability. Madam Speaker, the general consensus of the various societies affected by the practice considers it worse than murder due to the gruesome way it is performed. Right Honorable members, I would like to refresh your mind that when we were consulting as we drafted this bill across the country, the tales of stories of what the victims of human sacrifice went through and the parents was so agonizing, Madam Speaker. And therefore, before a person dies, the pain that the victims suffer is more than just treating this case as a murder case, Madam Speaker. And for that reason, that we are proposing that we need a standalone law that will treat human sacrifice as a criminal offense and give it the punishment that it deserves, especially for those who are practicing it. The reported cases indicate that whereas the perpetrators of human sacrifice are mostly witch doctors and traditional healers, the financiers of the practice are often wealthy individuals who are never prosecuted, Madam Speaker. The remedies proposed in the bill are to provide for the offense of human sacrifice with specific ingredients and to provide for deterrent penalties and fines, also provide for the other preventive measures against the practice. Madam Speaker and honorable colleagues, we have a familiar case that involved one of the prominent businessmen in Masaka, the one called Kajubi, Kato Kajubi, who had been left off the hook, but after a second thought by the DPP and a lot of pressure, this case was retried and Kato Kajubi actually was brought to book and eventually convicted. Madam Speaker, this indicates that there are loopholes in spite of the fact that we have existing legal regimes, including the Penal Code Act, necessitating for us to have this standalone bill to be able to address squarely the act of human sacrifice. Madam Speaker, I beg to move.
Thank you very much, Honorable Atiku. Can we invite the committee report? Yes, Honorable Akamba.
Right, Honorable Speaker and honorable colleagues, I seek your indulgence that in the interest of time, I present an abridged version of the report. For a more detailed analysis, I would refer honorable members to the main report uploaded on their respective iPads. You may recall that on the 8th of April 2021, this House referred a bill entitled the Prevention and Prohibition of Human Sacrifice Bill 2020 to the Committee on Legal and Parliamentary Affairs for scrutiny and report back pursuant to Rule 128 of our Rules of Procedure. Right, Honorable Speaker, this private members bill seeks to, among others, provide for the crime of human sacrifice, provide for fines and penalties for the offense of human sacrifice, and for related matters. The committee notes that human sacrifice is a growing concern to law enforcement agencies, parents, child rights activists, and the general public. Records from the Uganda Police Force show that human sacrifice cases have been steadily increasing for the last several years, with more complicated and grim methods being introduced by perpetuator every single day. The few provisions under the Prevention of Trafficking in Persons Act 2009 are brief and do not capture all the possible scenarios, causes, and elements surrounding this crime, leaving much room for ambiguity. The few provisions which exist against human sacrifice are found within a law which is unrelated to crime, and the existing provisions have been written with the intention of preventing trafficking in persons and not human sacrifice. As a result, these provisions are lacking the key elements unique to the offense of human sacrifice. As a matter of methodology, Right Honorable Speaker and the honorable colleagues, The committee wrote to and received a written memorandum from selected stakeholders as enumerated in the main report that can be accessed on the members' iPads. The committee could not meet face-to-face with them because of the tight schedule of the budget process. Right, Honorable Speaker and colleagues, the committee examined the following proposals in the bill and reports as follows. 1, definition of human sacrifice. The bill in clause 1 seeks to define human sacrifice to mean the killing, mutilation, removal of organs or body parts of a person for sale or for purposes of witchcraft, rituals, or any other harmful practices. The committee has considered the proposal to define the phrase human sacrifice and is of the considered opinion that the provision does not go far enough to deal with all the aspects of human sacrifice. The committee is aware that it is not only human organs and body parts that can be removed or mutilated from a person, since practice in relation to this offense shows that human blood and human tissues can also be removed in furtherance of this offense. The proposal, therefore, to limit the offense to only human organs and body parts will create a gray area in the law and will lead to abuse of the provisions of this law. The committee recommends that A, the definition of the phrase human sacrifice should be expanded to include the removal or mutilation of human tissue of a person and the drawing of blood from a person. B, for clarity, define all of the words that are ambiguous. 2, offense of human sacrifice. Clause 2 of the bill creates the offense of the human sacrifice, and it requires that the offense is committed when one mutilates or causes the death of another person for the purposes of performing or furthering a ritual. Whereas the committee agrees with the principle to create the offense of human sacrifice, the committee is concerned that there are a number of issues that may affect the effectiveness of the bill. For instance, the committee notes that there appears to be a conflict between the definition of the phrase human sacrifice and the offense of human sacrifice being created under clause 2. The committee observes that for the offense of human sacrifice to be committed as proposed in clause 2, one must cause the death of another person for purposes of performing or furthering a ritual, while clause 1 defines human sacrifice, therefore the offense of human sacrifice, in broader terms to include, among others, the mutilation and removal of body organs and body parts. This perceived conflict will affect the effectiveness of the offense since it will not be in tandem with the definition of the phrase human sacrifice, thereby making the work of the prosecution difficult. The committee recommends that A, the definition of human sacrifice in clause 1 and the offense of human sacrifice in clause 2 should be harmonized. B, the punishment proposed in the bill should be commensurate with the act or omission that constitutes the offense, therefore. The death penalty should be imposed on a person who commits the offense where such a person is a parent, guardian, or person having authority or control over the victim of the offense, or where the act results in the death of the victim. And in other cases, where a person causes grievous bodily harm to the victim, the person should be liable to imprisonment for life, and if the person causes any other injury to the victim, the person should be liable to imprisonment for 10 years. C, the provision should also punish a person who carries out human sacrifice on himself or herself to ensure that there is no loophole that can be used to defeat the purpose of the act. admissibility of accomplice evidence. The bill proposes in clause 8 to allow the admission of accomplice evidence without the need for corroboration. This provision will allow the prosecution to rely on the evidence of an accomplice without need for corroboration. The committee notes that currently, Section 132 of the Evidence Act directs that an accomplice is a competent witness against an accused person, and a conviction is not illegal merely because it proceeds upon the uncorroborated testimony of an accomplice. The committee is concerned that the proposal to remove the requirement for corroboration will be abused and may result in a miscarriage of justice. The committee therefore recommends that clause 8 be deleted with the justification that the provision will result in the use of uncorroborated evidence whose credibility cannot be assured and may result in the conviction of otherwise innocent persons, thereby constituting a miscarriage of justice. Compensation, rehabilitation, or restitution to be made in certain clauses. Clause 10 of the bill proposes to make provision for compensation, rehabilitation, or restitution to be made in certain cases. The provision allows the payment of compensation to a survivor of the offense or his family or dependent, as well as rehabilitation of the survivor of the offense. Whereas the committee is agreeable to the principle to direct for the payment of compensation, rehabilitation, or restitution, the committee is of the considered opinion that the provision needs to be strengthened to ensure that the provision is effective. One of the ways this can be achieved is through requiring a victim assessment to be carried out to examine the extent of the injury on the survivor or the family or dependents of a person, which will in turn guide the court in making the orders to compensation, restitution, or rehabilitation. In light of the above, the committee recommends that clause 10 stands part of the bill, albeit with the amendment to require an assessment to be carried out on the victim of the offense to determine the damage caused to such person as a result of the offense of human sacrifice, and to ensure that at all times during a criminal trial, adequate provision is made for dealing with physical and psychological effects of the offense of human sacrifice on a person without necessitating the institution of civil proceedings against the perpetrator of such crimes. The committee studied other proposals in the bill, like the duty to report acts of human sacrifice, the need to harmonize the bill with the Prevention of Trafficking in Persons Act 2009 and 2019, and made recommendations. I encourage honorable members to find the details in the main report. Right, Honorable Speaker, the committee would like to make some general comments that we found lacking in the bill, which thought would help to enrich it. For instance, the committee observes that a provision should be made for inspection of places where human sacrifice is likely to take place. This will empower a person authorized by the minister to, after giving reasonable notice, inspect any house, building, or any place in which he or she has reasons to believe that the offense of human sacrifice is taking place or is likely to take place. This will ensure that offenses are detected early and deterred before they can happen. The committee also proposes that the bill should include provisions on extraterritorial jurisdiction to ensure the prosecution of offenses committed outside Uganda in circumstances where the person against whom the offense is committed is a citizen of Uganda, or is ordinarily resident in Uganda, or where the perpetrator of the offense is a citizen of or resident in Uganda. This will close a lacuna in the law which can be exploited by perpetrators of these crimes by having Ugandan citizens or residents sacrificed outside the territorial jurisdiction of Uganda, while either being Ugandan citizens or residents, or where the perpetrator is a Ugandan citizen. The committee also notes that there is need to clearly disregard certain defense that would ordinarily be available to a person under criminal law. The committee notes that in some offenses, consent is a defense to a charge and may be available to a person who commits the offense of human sacrifice by alleging that the victim of the offense consented to the acts that would constitute human sacrifice. In such instance, save for acts involving the killing of a person who mutilates another person and takes away body part, blood, tissue, or organs of another person can allege that the victim compensated to that removal of body organs, tissue, blood, or organs. The committee further notes that there is need for the minister to report on the implementation of the bill to Parliament. This will enable Parliament assess the effectiveness of the bill by examining how the bill is applied as a measure to curb the increasing cases of human sacrifice. The committee therefore recommends that the provision is made in the bill requiring the minister to annually submit to Parliament a report on the implementation of the bill. Consent of victim of an offense should not be a defense to a charge under the Act. The minister should be given powers to appoint authorized officers for purposes of inspecting places where human sacrifice is likely to take place. For extraterritorial jurisdiction of the bill, Right, Honorable Speaker and honorable colleagues, I beg to report and seek your indulgence that the bill is read the second time and do pass subject to amendments. Right, Honorable Speaker, I have the minutes of meetings of the Committee on Legal and Parliamentary Affairs Committee to review the draft report and submissions of select stakeholders on the Prevention and Prohibition of Human Sacrifice Bill 2020, held on the 29th April 2021 in room 139 of Parliamentary Building. And I have a signed report of the Legal and Parliamentary Affairs Committee on the Prevention and Prohibition of Sacrifice Bill 2020, which I beg to lay on table.
Thank you very much, Honorable Chair and members of the Committee on Legal and Parliamentary Affairs, for your expeditious handling of this bill. Honorable members, you have heard the motion, you have heard the justification, you have received the report. Are there any comments? Honorable Sechko, Honorable Tumuzigu, Babadiri, Ababiku. No, go ahead.
Thank you, Right Honorable Speaker and members, and I would like to thank the Committee of Legal and Parliamentary Affairs for the report, as well as the minority report by Honorable Akamba. Right Honorable Speaker and members, Honorable Akamba has attempted to widen the scope of human sacrifice by adding the removal of organs, the harvesting of organs, human organs, to be a wider form of human sacrifice. I just needed some small clarification. There is the mutually agreed harvesting of these organs. There is a mutually agreed situation where a patient looks for a relative to donate an organ to the sick person. would that also qualify to be amongst the harvested organs? A clear demarcation hasn't been made to us. And more often we are hearing those conditions where a patient, say having kidney failure, would seek for a relative, a friend, a donor, etc. Now, the tricky part of it is we do not know for sure if that medical condition can be helped for the donor to come out alive. But suppose the donor whose organ was harvested or was removed subsequently dies. I think, Honorable Kamba, you'd tie the loose ends on the harvesting of the organ to demarcate between the voluntary and the involuntary.
But Honorable, harvesting, the word harvesting is different from donor. You know, a donor, an organ donor is an organ donor. But when you say I'm harvesting, collecting organs as if it is a garden.
Right, Honorable Speaker, let's talk about the removal. The removal of the organ, whether it is harvested, probably that was on a higher side, but we agree on the giving and the removal of an organ by consent or for monetary reasons, but in a way where the two parties have agreed to that end. Madam Speaker.
Well, I'm not the mover of the bill, but I think what is in mind is, for instance, organ removal by trickery. For instance, you take me, say I'm going to do a job, then you drag me and then take out my organs. This has been happening to some of our people. Don't think organ is completely different from this, I believe. Yes, Honorable.
Thank you very much, Madam Speaker. Madam Speaker, the information I wanted to give is that sometimes also in Karamoja, human sacrifices are made in order for successful maybe attack or raids. Most of the time they bisect the human being and they target people like with the diastema, which is like a gap in between the teeth. Sometimes someone with a big umbilical cord or twins. So they sacrifice them not to remove the organs, but to bisect, and then the raiders can now pass through the person in between the bodies. So it's not only for removing the organs, but there are different types of sacrifices that happen in different communities. Thank you very much, Madam Speaker.
Hey. I hope we shall distinguish that issue. Ona Tumuzigu, very quickly. Tumuzigu, Babadiri, if someone could help on Babadiri to move towards the podium. Babiku and then Bahati. Then we
Thank you, Madam Speaker. I'm coming on the floor of Parliament when the word sacrifice is being widened. But Madam Speaker, I have to concentrate on what the committee is talking about. We are happy that at this point, we are bringing a law that will stop people from sacrificing others. Indeed, sacrifice is not only murder, it is beyond murder. And having a law specifically against human sacrifice is so important because human beings have got a right to life. And internationally, it is recognized. And even all cultures recognize a right to life. So it is timely, and I want to thank the committee for the job well done. But Madam Speaker, this report brings in the issue of the minister. The minister is a political head of the ministry, and I don't think the minister is more technical to handle the issues of supervising that area very well. Because they talked about investigations, the minister visiting the areas or the places which are expected to have such activities of human sacrifice. So I wonder how the minister will be able to do that job. I would propose that we leave that job to the police or another technical people who can really investigate very well matters of human sacrifice. Thank you, Madam Speaker.
Thank you, Honorable Badiri. Then Honorable Ababiku. Then Honorable Mujuke.
It's not coming. Hello. Okay. Thank you, Madam Speaker. Madam Speaker, I would like to thank the Committee on Legal and Parliamentary Affairs for the good report. Madam Speaker, child sacrifice or human sacrifice has become too common. And those who do it believe that when they have done it, they will become rich. Or their programs or their projects will develop. For example, when they build big, tall buildings, they sacrifice human beings. It has become so common that children are really suffering. Children are disappearing. Even grown-ups are suffering. Now we have become like sheep, which is sacrificed in the past. But even today, sheep are not sacrificed like human beings. So this law has come in time to deter people who are doing this. Madam Speaker, they target the vulnerable people, like the children, very innocent, and they give them away. Even the mother, the parents, they want to make money out of human beings, which is not fair. You don't produce it to sacrifice or to give away to make money. Then you find the disabled, especially the albinos. You find that they are sacrificed. They believe that if they take their parts, you become very rich. And they are at a big, big, big risk. And the issue of exporting even these human beings, it is common. We need to trace them. For example, it is common in Tanzania, where the albinos are targeted. And even they have come here to Uganda. They pick from here and go to Tanzania to sacrifice. So that one we need to trace up to the place where they are sacrificed. And if necessary, we find out exactly what has happened so that we stop this problem of child sacrifice. This law, when it comes in place, we need to implement it so that it helps. Madam Speaker, I would like to find some clarification also from here. There is a kind of sacrifice very common in Congo and even in Uganda now. We call Abiba, where you come and you bewitch some people and they die. They say even a whole clan can be registered and they die. Where do we put this one? Because it has become very common. At times they tell lies that because you have become very rich, you have sacrificed human beings. And even they kill that young man who is so progressive. So it has become a problem. I don't know where we can put this and whether we can include it so that those who are practicing Abiba can also be arrested. Thank you, Madam Speaker.
Thank you very much, Honorable Ababiku.
Yes.
Honorable Mujuke.
Thank you, Right Honorable Speaker, for the opportunity. I want to thank Honorable Bernard for this move and also the committee. I support the committee recommendations. Right Honorable Speaker and colleagues, in my view, we should move for a total deterrence of this act. I have listened from the committee report. They are proposing varied penalties. In relation to one, if the crime is committed by a parent or by a relative or a guardian vis-a-vis a person who is not closely linked to the victim. They indicated that for a person who is a relative or a caretaker or a parent, the penalty is death penalty. But for other people, they have lessened the gravity of the penalty. Right Honorable Speaker and colleagues, this is an act, to me, whether it is done by a relative or not, it is a grave act. Elimination of somebody, killing of somebody, taking away somebody's life, forcefully should not be tolerated. Right Honorable Speaker and colleagues, I am of the view that a person or any other person who is not even a relative who gets involved in this act should be treated in the same penalty. Because giving pardon and also giving room for others to know that if I do this, since I'm not a relative to so and so or to this child, I will have a less penalty, to me is going to create a room for an abuse. Right Honorable Speaker and colleagues, I am interested on how we can handle a scenario where victims are rescued. Often others are rescued when they are not harmed, but in the course they get dramatized. How are we going to provide counseling services to them? Which institution is going to handling counseling service to these children or to people who get rescued? Two, I also think when we get these children or any other person who has been rescued, that person has to be compensated. Two, there are cases where we get them rescued, but they are harmed. Therefore, it also provides for counseling and compensation. I pray that we provide for specific provisions to give second hope for these people who become victims, but they get rescued so that they are counseled to regain their hope to live for more years, but also their protection, but the aspect of compensation too. Thank you so much, Right Honorable Speaker and colleagues.
Thank you, Honorable Mujuke. Mujuke, Ungeto, Nawat, and Koni.
Thank you so much, Right Honorable Speaker. Right Honorable Speaker, human sacrifice is not only primitive, but it is inhuman and archaic, and it should be penalized. Some time back, I remember when we visited Abu Dhabi, there are some young people who came to us and they were telling us stories of what happens there. People who go to work in foreign countries and they are forced, sometimes unaware, they get out your body parts, your kidney is taken, and they force you to come back to Uganda. A few months after you have come back, you start getting pain. On with check, you have one kidney. And the companies are here. Some of these companies are here. And now that a law is coming up, Madam Speaker, I want to support such a law so that these companies can be brought to book and there is penalty for them. I want to thank the chair of the committee. I want to thank Honorable Atiku for this good law, and we should support it. Thank you very much.
Honorable Ongeto, Nawat, Koni, then we end with Centenary and Bahat.
Madam Speaker, thank you for this opportunity. I want to thank the committee for the good report, and I also want to thank my friend Honorable Atiku for bringing this law. Madam Speaker, I support the recommendations of the committee, but I want to suggest a modification that the people who are involved in this practice and found guilty should be taken to be tried by the military. Because for me, These are worse than some of our friends who are finding themselves in the military court. And after trial and found guilty, I am recommending that such people should be put to the firing squad. Because we really want to deter people from this practice. And number two, Madam Speaker, I want to bring the case that my colleague from Koboko brought. Madam Speaker, it's a practice that we used to hear from Congo, but now it has come amongst our people. And amongst the Alur and Jonam people, they call it Joro. You know, it's like, I want to be rich, I will identify either my child or relative or some other person, then I would, and most of the time the people are going actually to Congo to consult the witch doctors there. And they will do whatever we don't understand, but at the end of it, you see this person's child dying under unclear circumstances. And a lot of times why people suspect their parents is because when the child is sick, you see the parent unconcerned. And that is why they become the first suspect to the ordinary people. And Madam Speaker, as we speak, because people know that it's very difficult to prove such a case in the courts of law, people are resorting to now mob justice, and many people have been killed in that process. Some of them afterwards discovered they were killed innocently, but some of them are killed, maybe we can say rightly. Although, of course, I don't want to say I have proved myself. But it is something we need to take interest in because it is really expanding. And our people are suffering from it so much psychologically. Because now you never know what is happening. And unfortunately, it's also coming into politics in the sense that you can hear maybe the other candidate is very sick, the other candidate has died, and some of our people say, you know, that person has been sacrificed by another candidate. So it's so unfortunate. It's something we need to take interest in, but maybe we can't mix it with the current law that is being proposed. I thank you, Madam Speaker.
Thank you, Honorable Nawat. Nawat Koni, Centenary, Nabat.
Thank you, Madam Speaker. And I would like to thank the mover of this private members bill and the committee. Madam Speaker, there are artless people in this world. In a bid to fulfill their own interests, they do so at all costs, including sacrificing human life. In the 9th Parliament, I was on the Committee of Gender. And that time there were many incidences of human sacrifice. And we picked interest as a committee. We moved around to those areas where those incidences were heard of. We went to Mukono. We went to Nachitoma in Nakasongola district. Madam Speaker, we interacted with the communities there. We interacted with the survivors. We interacted with the parents. Some parents had even lost their children. We were shown terrifying photographs. Madam Speaker, they showed us a photograph of a boy whose head had been chopped off. We also saw a photograph of a young girl whose private parts had been removed, and the survivors had scars on their bodies. Madam Speaker, the survivors were only able to survive because of the intervention and support from NGOs. Some of these cuts were so deep that it necessitated flying these children abroad. There was a young boy, they told us they flew him to Australia. And Madam Speaker, most of these children are children from poor backgrounds. If it were not for the intervention of NGOs, such children would have not had a second chance to survive. Madam Speaker, the communities tried their best to report such incidences to police. but the police take long to react. In Nachituma, for example, there was a senior six-packist who had been killed. The community members reported the case. Well, police came and they traced the drops of blood up to some shrine. Reaching there, they collected the blood samples. Now, when we asked the community members, they said they told them the blood samples had been taken to South Africa. And it was such a long time from the time they took the results. So, Madam Speaker, if justice is to be given to these people, government should really act. Madam Speaker, it's good that the committee has recommended stringent measures, including imprisonment for life and death sentence. Madam Speaker, I call upon government to act swiftly. For example, in this case where blood samples are flown out of the country, the Directorate of Government and Analytical Laboratory should follow up so that justice is dispensed. I beg to submit, Madam Speaker.
Thank you. Honorable Gariwango. Gariwango, Centenary Develop, and then Honorable Bahati.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I want to thank the committee for the report, more especially Honorable Atiku for bringing up this bill. In fact, it's long overdue. Right Honorable Speaker, human sacrifice is not only inhuman, but it's evil, very evil. Right Honorable Speaker, I'm not comfortable about the punishment that is segregative. Like Honorable Abiku put it, if it is the parents who have sacrificed their children, or vice versa, it's a death penalty. And then the others, it's imprisonment. Right Honorable Speaker, as long as a life has been taken away, these people should be dealt with equally. If it is a death, well, I may not be somebody who wants to advocate for death, but if it is death, let them all die. If it's life imprisonment, let all of them be imprisoned for life. Like some of the holy books put it, that an eye for an eye. I pray that this will be a big deterrent, given the fact that all those who have practiced it have not faced any kind of punishment that can scare anybody. That's why it's going on. But if there is a stern punishment, I think it will go. And then some parents who think death will occur to them can hire some people to do it for them, so they may still escape the death. So if it is an equal punishment, some of these will try to do it. Right Honorable Speaker, everybody I think is vulnerable. It's not only a few, maybe the children, but wives are vulnerable, husbands are vulnerable. The albinos, people with gaps now in Karamoja, if you have a big umbilical cord, it's not your fault. If you're a twin, it's not your fault. If you're an albino, this is God's design. So everybody is culpable. Everybody is a victim. Therefore, if we have stern punishment, it will be a big deterrent. Right Honorable Speaker, the police has tried to help, but police is very slow. Can there be some measures put across that might be a timeline, that if such has happened, then within such a time, it must be handled expeditiously. Otherwise, if it is at their own lax, it takes a long time and the families remain traumatized, the victims are traumatized, and eventually they don't fit in society. Right Honorable Speaker, I beg to submit.
Thank you, Honorable Centenary. Then the Leader of Opposition, and then Honorable Bahati.
Thank you, Right Honorable Speaker, for giving me an opportunity to contribute to this bill. It's really long overdue. I recollect one time as a children's forum, we went to Luwero to visit some victims of human sacrifice. And one of them, actually the twins, somebody had attempted to pick organs from the twins. One of the twins survived, another one did not make it. And when we were visiting the grave of the other twin with the relatives of that surviving twin, he actually broke down. And these memories are still very fresh in my mind. So when we are processing this bill, I think we should put in mind that even we ourselves, like me, I have a natural gap. So in Karamoja, I am a victim. I'm equally a victim. And also our children or our grandchildren can be victims of this human sacrifice. The bill reads prevention and prohibition. And for it to make meaning, the punishment should be actually preventive and prohibitive. And therefore, I think it is proper that we harmonize, and I would beg for the indulgence of the committee to concede that we have a punitive measure of death harmonized across all the people, the ones who abet with crime and the ones who commit crime, because they will conspire. You know, Ugandans have become innovative. Actually, the people who can even have no mercy for the victim are those who are not even the parents or relatives, because perhaps some relatives may feel shy that the clan is going to excommunicate them. But if I am not related to you, I have no moral authority to even have pity upon your child or you yourself. But also we are having a big challenge with the leadership, the LCs and the police. Sometimes these cases are reported, but because the people who do the human sacrifice reap big from these body parts and organs, they compromise the leaders from pursuing these cases. I think they should also be brought into the loop of the people who are supposed to be punished, especially if it is proven beyond reasonable doubt that there was a case reported at the LOC or police, and the police decided to conspire with the people who have sacrificed humans. Otherwise, life is precious. If we want this law to have meaning and retire very well, like some of us who are going into the senior citizens docket, we need to pass a law that is going to at least help this country reduce, because we may not stop. Some people will do it undercover on this vice of human sacrifice. And then we have these albinos. These people have become the biggest victims, actually, of that sacrifice. Probably, if we decided, we could categorize them into the most vulnerable, because those ones are very, very, very vulnerable, especially now that it's becoming a global issue. In Tanzania, they are looking for their body parts. In Kenya, they are looking for their body parts. Probably, I would agree that the punishment, if there was a punishment bigger than death penalty, I would advocate for that. I beg to move.
Honorable Leader of Opposition. Honorable Bahati.
Thank you, Right Honorable Speaker. And I would also like to thank Honorable Atiko for this bill. In this term's parliament, he has been working tirelessly. And at the end of it all, we are now able to deliberate on this bill. He worked so much for children. While adults are also victims of this human sacrifice, the main victims are children. We saw some in Gulu. I am very sure that the people involved are still behind bars, but you will find that it is mainly the children. And it is sometimes because of primitive cultural belief. First, to think that you go to a witch doctor to give you riches. And how rich is this witch doctor? You find a witch doctor in a grass-thatched hut, and you think this witch doctor is going to give you wealth, and you do away with the life of a child. It happened in a what? It happened in is it in Buatira? This was very, very bad. You cannot just go to get wealth through sacrificing children. And for me, I kept on telling them that, do you eat human flesh? If you don't eat human flesh, why should you kill? When I was in primary, my grandmother used to tell us, be careful of people who sometimes go to look for children. And it was usually children with big umbilical, very big. And they see if you have that, they get a way of getting you. And they pay money. My grandmother used to tell us that they would pay money maybe to teachers. And you disappear. You know, those days we would go for physical education. Not completely, you remove your what? You remove your dress and you remain in pajamas. So you play and they are able to see now what is this that we need. I think those are all primitive beliefs. They should all go. And this law will help to completely clear them. The alarm we made a lot also helped. I also want to say that also parents used to sacrifice their children. This I was told that if you produce an abnormal child, then you go to a flowing river, a river. You go to a river and you make sure that you tie this child, but not strongly. And you just leave the what? Leave the clothes off, and the child falls into the running water, and you make an alarm as if you are sorry for the what? For the death of the child. And yet it was intended by you to do like that. So we must thank God for bringing this Bible to us, that a disabled child should be taken care of more than an able child. A disabled child should not be looked at as a curse. That child did not ask for that abnormality. Just you found that you have a child like that, should be cared for. So if we leave these primitive practices, it is primitivity. If we leave, we go to the Bible. The Bible helps us. We say that wisdom is knowing God. And when we know God, we accept what God has given us. But if we are not wise, then we think this is a curse. How can I get rid of it? And getting rid of it is sacrificing. And it's mostly children. For the adult, yes, they are victims, but not very often like children. So thank you very much for this bill. And this bill should be passed as quickly as possible. It should have been passed yesterday. Probably the sentence should be looked at and made to be strong to deter people from killing children. We should never kill children. Thank you, Right Honorable Speaker, and thank you, Honorable.
Honorable Bahati.
Thank you very much, Madam Speaker and the honorable colleagues. Madam Speaker, human sacrifice anywhere in the world is a creeping human danger to the human race. And therefore we condemn it wherever it takes place. Madam Speaker, it is very shameful that we note that now these criminals who are involved in human trafficking earn over 30 billion US dollars every year. 30 billion US dollars is registered as earned by the network of these criminals. And over 2.4 million worldwide are affected by this evil and dark business and practices. So we want to thank the Honorable Bernard Atiku, who has been at the forefront for issues regarding children. Even when we know that you are going for the sabbatical leave, but you leave the 10th Parliament knowing that we have made a contribution. And we are very, very, very grateful for what we have done on our behalf. Madam Speaker, we also need to thank the Honorable, the Justice Michael Chibita, who really made this an issue when he was still in the High Court, I think in Masaka, when he made that ruling against one called Kajubi, when it was a very, very difficult case, but he stood firm and he ruled in favor of the victim. And we are very grateful that now he now sits at the Supreme Court bench. So this contribution we are making as 10th Parliament, it's really a signal to these criminals that business is not going to be as usual. And I think we must strengthen the punishments and the offenses. I have read the chair of the committee proposing that attempting to do human sacrifice should only attract 10 years. I think 10 years is very little time. It's very little time. We should strengthen it so that we help to curb this crime once and for all. There are areas where we have seen people cannot erect buildings unless they have done some sacrifice, human sacrifice of some sort. We have registered them here in this country. It's very, very shameful that you cannot get out of the foundation unless you have shed blood of somebody created in the image of God. So the 10th Parliament, Madam Speaker, is doing and is ending at a very good note by passing this important bill. Regarding other, the Honorable Sechkubo was wondering whether we are going to confuse donation of these organs for health reasons and human sacrifice. As the Minister of Health, Madam Speaker, one time mentioned here, at cabinet level, we have passed a law that is going to manage the donation process of these organs, special organs, for purposes of health, the kidneys, the liver, and all that. So the bill will be coming in the next cabinet, rather in the next parliament, so that we can handle that, because we know it is also a major issue that's affecting the health of our country, but should be managed in a very, very, very strict and organized manner. That's why we had to move the bill. The Minister of Health had to move a bill in cabinet, and we passed it, and it will be coming. So, Madam Speaker, we are very grateful once again for Bernard Atiku for your contribution, and we wish you very well in your sabbatical leave. And we hope that you'll come, when you finish the sabbatical leave, you'll come with many bills of this nature to protect our children. Thank you very much.
Thank you very much, honourable members. I put the question, that question be put. Those in favor say aye, the contrary no. And I put the question that the Prevention and Prohibition of Human Sacrifice Bill 2020 be read for second time. Those in favor say aye, the contrary no. Let's have it.
The Prevention and Prohibition of Human Sacrifice Bill 2020. Bills Committee stage. The Prevention and Prohibition of Human Sacrifice Bill 2020. Clause 2.
Honourable members, I put the question that clause 2.
Clause 2.
Honourable Chair, you have an amendment.
Madam Chair, I have amendments clause 2. Clause 2, offense of human sacrifice. Redraft clause 2 as follows. 2, offense of human sacrifice. 1, a person who carries out human sacrifice commits an offense and is liable on conviction to the penalty prescribed in subsection 3. 2, a person who carries out human sacrifice on himself or herself commits an offense and is liable to imprisonment for 10 years. For the purposes of sub clause 1, where A, the person who commits the offense is a parent, guardian, or person having authority or control over the victim of the offense, the person is liable to suffer death. B, the offense results in numero 1, the death of the victim, the person is liable to suffer death. 2, grievous bodily harm to the victim, the person is liable to imprisonment for life. 3, any other injury to the victim, the person is liable to imprisonment for 10 years. Subclause 4, in this section, A, grievous bodily harm means any harm which amounts to a mayhem or dangerous harm or seriously or permanently injuries, health, or which is likely to so to injure health, or which extends to permanent disfigurement, or to any permanent or serious injury to any external or internal organ, membrane, or sense. Justification: for clarity and to remove a conflict in this clause and the definition of human sacrifice under clause 1, to expand the provision to punish persons who carry out human sacrifice on him or herself. Consequential amendment arising from the amendment of clause 1 of the bill, wherein the matters in clause 2, subclause 2 have been included therein. To prescribe different punishments based on the severity of the injury to the victim of the offense and the relationship between the victim and the perpetrator of the offense.
Now, members, the question is that clause 2 be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 2 as amended.
Question is that clause 2 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 3.
Honorable Chair, clause 3.
Clause 3, offense of financing human sacrifice. Clause 3 is amended. A, in the head note by inserting immediately after the word financing, the word or facilitating. B, in subclause 1, by inserting immediately after the word finance, the words or facilitate. Justification, to expand the provision to include a prohibition on the facilitation of human sacrifice in addition to financing of human sacrifice.
Members, question is that clause 3 be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 3 as amended.
Question is that clause 3 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 4.
Honorable Chair, clause 4.
Clause 4, attempt to commit offense of human sacrifice and financing of human sacrifice. In clause 4, insert immediately after the word financing the words or facilitating wherever the word appears. Justification, to expand the provision to include a prohibition on the facilitation of human sacrifice in addition to financing of human sacrifice. Consequential amendment arising from amendment of clause 3 of the bill.
Members, put the question that clause 4 be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 4 as amended.
Question is that clause 4 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 5.
Honorable Chair, clause 5.
Clause 5, prohibition of certain harmful practices relating to human sacrifice. Clause 5 is amended in paragraph A by deleting all the words appearing after the word sacrifice. By substituting for paragraph C the following. C, encourages or advises any person to use a human body part, a human body organ, human tissue, or human blood, or any product or concoction derived from a human body part, a human body organ, a human tissue, or human blood in any ritual, treatment, or healing. By deleting paragraph D, by inserting immediately after paragraph F the following: offers himself or herself or the service of another person for purposes of committing the offense of human sacrifice. Justification, the amendment in paragraph A is intended to expand the provision and make irrelevant the purpose for which the spread of belief in human sacrifice is made for. The amendment of paragraph C is for purposes of expanding the provision to include a human body organ, human tissue, human blood, or any product or concoction derived from a human body part, a human body organ, a human tissue, or human blood, and to merge paragraph C and D since they relate to the same matters. To criminalize the offering of oneself or another person to commit the offense of human sacrifice.
No members, put the question that clause 5 be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 5 as amended.
Question that's clause 5 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 6.
Honorable Chair, clause 6.
Clause 6, possession of human body parts and instruments of human sacrifice. Clause 6 is amended in paragraphs A and B by inserting immediately after the word parts the words or a human body organ, a human tissue, or human blood. In paragraph C, by inserting immediately before the word makes the words unlawful. Justification, to expand the provision to include human body organs, human tissues, or human blood among the matters a person may not have in his or her possession. Due to the diverse instruments that may be associated with human sacrifice, some of which may have lawful uses and also may be used as teaching aids in the fight against human sacrifice, to limit the offense to only persons who have those items unlawfully.
Members, I put the question that clause 6 be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 6 as amended.
Questions clause 6 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 7.
Put the question that clause 7 do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 8.
Clause 8 is for deletion.
Clause 8, admissibility of accomplice evidence. Clause 8 is deleted. Justification. The proposal in clause 8 will disregard a rule of practice which requires the corroboration of accomplice evidence of persons who are charged with the same offense under the same charge sheet, and one of them pleads guilty and then gives evidence against the other person. This rule of practice is born out of the realization that accomplices are usually interested parties who may be giving evidence merely for purposes of saving themselves from criminal liability, and therefore such evidence is regarded as untrustworthy by courts of law. The reason is that the accomplice is likely to tell lies in order to shift guilt from himself or herself to play down the part that he took commission in the offense. Since the evidence of an accomplice is treated as untrustworthy, for such evidence to stand, it must be corroborated by additional independent evidence, which increases the credibility of such evidence. Clause 8 will therefore result in the use of uncorroborated evidence whose credibility cannot be assured, and may result in the conviction of otherwise innocent persons, thereby constituting a miscarriage of justice.
Members, put the question.
Insertion.
No, the members have put the question that clause 8 be deleted. Those in favor say aye, the contrary no. Ayes have it. So new clause.
Insertion of new clause immediately after clause 8. Immediately after clause
7.
8.
After clause 7. Because you have deleted 8.
Immediately after clause 7. Immediately after clause 7, insert the following new clause. Victim impact report. Subclause 1, the prosecution shall, when prosecuting offenses under this act, carry out a victim impact assessment to determine the impact of the offense on the survivor of the offense or any other person. 2, the victim impact report shall take into account A, the condition of the survivor or any other before and after the commission of the offense. B, the nature of harm the survivor or any other person faced. C, whether the survivor or any other person faces or is likely to face any long-term physical or psychological trauma necessitating the provision of long-term medical care or any other assistance. D, whether the survivor or any other person can recover or return to normal life and be integrated into normal society life. And E, any other information as may be required by statutory instrument. Subclause 3, the victim impact assessment shall be adduced in evidence following conviction and shall guide the court in sentencing and in awarding of compensation, rehabilitation, or restitution. Justification: to provide for the carrying out a victim impact assessment in order to determine the effect of the offense on the survivor or any other person, so that appropriate orders can be made by court to cater for unique circumstances of the victim or the survivor of an offense under the Act.
Yes, Honorable Songo.
I want to thank the chair of the committee. Madam Chair, I think here there's something lacking. The prosecution shall, when prosecuting offenses under this act, carry out a victim impact assessment. By who? Who has carried out? Is it a traditional doctor? Is it a registered professional? It must be clearly stipulated who is going to carry out this assessment. It must be a professional. Well, I want you to get because you will not use any report. It must be coming from somewhere. And it must be someone who is professional, accepted by court and the medical personnel. So that one's done, I want to correct. Otherwise, the rest are okay.
Madam Chair, the committee deemed it necessary to give the prosecution discretion to determine how this is done. So it's the discretionary power of the prosecution to determine who carries out the impact assessment.
And also, honor members, the prosecution is the state. So you can't expect a witch doctor to carry out an assessment on behalf of the state. Really? No, you can't expect a witch doctor to carry out the assessment. Yes, Honorable Bati.
Thank you, Madam Chair. First of all, allow me to support this proposal by the committee, which of course we did consider during drafting, but along the way, being a private member's bill, we feared that maybe we would not secure the certificate of financial implications. But on a further study, Madam Chair, just as Honorable Seung has said, we considered to accept this proposal on the basis that the state already has professionals that it employs that have capability to undertake such an assessment when there will be need. So initially, we had thought that the sitting judge or the presiding judge in his ruling would direct the relevant technical persons to undertake this assessment to be able to give the right prescription for the victims. But if you insist, we would add the proposal that Honorable Seung was trying to drive of adding a professional, that victim impact assessment to be determined by a professional. And for that matter, whether it will be for psychosocial matter or for financial matter or for health concerns. I beg to submit, Madam Chair.
I don't know, what does the chair say about that proposal?
Madam Chair, the committee still maintains that there is need for discretion in this case, because the impact assessment may be in form of psychosocial, medical, to determine the level of disability or financial aspect. So it should be given, the state should be given the discretion to choose who carries out the assessment. It should be a case-by-case basis. And Madam Chair, I would like to make some clarification in subclause 2A. The condition of the survivor or any other person, the word person is missing. And in subclause 3, the victim impact statement, we are replacing the word report for statement. So we cross out statement and replace it with the report. I beg to move.
That's where you, Mr. Chairman, I want you to look at my proposal. A, you are saying the condition of the survivor or any other before and after the commission of the offense. Meaning that they are going to have a number of professionals. But in my one, I was saying impact assessment by a professional. We could put something that gives powers to somebody who will give the report in that particular area, because we have given a number of them. But we don't, if someone registered the profession. You see, Madam Chair, in some instances, you will find that, yes, an offense has taken place, and you will get a report below the level of a person who is supposed to give it. And if you give it here, it saves you more. Thank you.
Honorable Seungu, I understand what you mean. However, I think if we are going to go into that, we may have to say a professional, a medical professional, a social worker, a psychologist. I don't know. I know what you mean, but how do we define that professional?
To avoid the multiplicity of different professions, I would say the prosecution shall, when prosecuting offenses under this act, carry out a victim impact assessment carried out by a professional to determine the impact of the offense on the survivor of the offense or any other person.
Yes.
Is it okay?
That means we will have also to define the professional in the interpretation section. That's what I'm talking about.
It's okay. We can define it, Madam
No,
Chair.
you know,
You can
that's why
define
I'm
it.
saying you will have to say professional means a medical officer, a social worker, a psychologist. You know. Yes.
Thank you, Madam Chair and honorable colleague. I would want to, from Madam Chair's guidance, agree that actually the original draft gives us leverage to be able to accommodate, or the presiding judge to be able to accommodate any professional. But if we are to put it here, that means we are going to limit, because we have to go back to the interpretation clause and list the professionals that will be associated with this. But we all know that human sacrifice takes different forms, and therefore for future cases, it will be important that we give this unlimited option for the presiding judge to be able to determine the kind of professional attention that should be, or service that should be rendered to the victims. Thank you.
Honourable members, I put the question that a new clause be introduced as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 9.
Clause 9, Honourable Chair.
Clause 9, psychosocial support to survivors of human sacrifice or attempted human sacrifice. Clause 9 is amended. A, in subclause 1, by inserting immediately after the word support, the words by state. B, by inserting immediately after subclause 1, the following. The minister may designate a person or organization to complement government in providing psychological support to a person who survives human sacrifice. Justification: to define who is responsible for provision of psychological support to a survivor of human sacrifice. To empower non-governmental organization designated by the minister to supplement government in providing psychological support.
Yes, Honourable Seungu.
I do pray that this the minister may, so it is at liberty not to. But since this person is already psychologically tortured, why don't you say the minister shall, or any, the minister shall designate a person or organization to complement government in providing psychological support. That means he has even delegated the authority. But when we leave it may, it's up to him. Today, this one we can leave, the other one. So let us say shall, because this person is psychologically tortured, and we are talking about human life, somebody who has gone through human sacrifice. So let us use shall, so that is commanding and it is a must for him to do so with his designation in hospitals.
Madam Chair.
Honourable members, if we say shall, it means we are directing the minister. I don't know whether this does not have financial implications. Because if the minister is going to be obliged to appoint, I don't know.
Madam Chair. Madam Chair, the intention of the committee was that there may be cases which may not necessarily require psychological support, but for such cases that may require psychological support, then the minister may choose either to choose a person or an organization. So in this case, it will be unwise to use the word shall.
Members have put the question that clause 9 be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 9 as amended.
Put the question that clause 9 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 10.
Honorable Chair, clause 10.
Clause 10, compensation, rehabilitation, or restitution to be made by court in certain cases. Clause 10 is amended by renumbering subparagraph and numeral number 3 of paragraph C as subclause 2 by inserting immediately after subclause 2 the following: the failure by the prosecution or any other person to apply for compensation, rehabilitation, or restitution shall not be a bar to a grant of compensation, rehabilitation, or restitution by court, save that where the court does not order for compensation, rehabilitation, or restitution, the person presiding over the trial shall give reasons for that decision. The court may order compensation to a person who spent money to help the survivor of human sacrifice under this act. Justification: due to the physical and psychological effects of the offense of human sacrifice and the need for adequate compensation or restitution to be made to guide court to make orders for compensation, rehabilitation, or restitution, and if none is made, to give reasons for such a decision. To ensure that at all times during a criminal trial, adequate provision is made for dealing with physical and psychological effects of the offense of human sacrifice on a person without necessitating the institution of civil proceedings against the perpetrator of such crimes. The renumber of subparagraph numero subparagraph for Roman 3 of paragraph C as subclause 2 is to remedy a numbering mistake.
The members have put the question that clause 10. Yes, Honorable Hillary.
Thank you very much, Chair. On clause 10, under compensation, rehabilitation, or restitution to be made by court in certain cases. I propose we say we insert competent court, because we also have local courts, LC1 courts and so on. So we should put the word competent court.
Has the court been defined in the interpretation section?
Madam Chair, it is not defined, but the committee looked at in the fact that most of the offenses under this act, the punishments are prescribed, and the punishment to a given offense determines which court has jurisdiction over it, either Chief Magistrate Court or a High Court. Yes, move on the bill.
Thank you, Madam Chair. I want to thank honorable colleague for raising this concern, but this is a criminal offense. And therefore, Madam Chair, I think in our country, criminal cases are only tried before well-established courts that do not need any further definition. So this is a criminal offense, and therefore, my colleagues' fears should be addressed. Thank you.
Members, I put the question that clause 10 be amended as proposed. Those in favor say aye, the contrary no. Let's have it.
Clause 10 as amended.
Question is clause 10 as amended. Do stand part of the bill. Those in favor say aye, the contrary no.
Clause 11.
Honorable Chair.
Clause 11, duty to report acts of human sacrifice. For clause 11, there is substituted the following: duty to report acts of human sacrifice. Subclause 1, a person who knows or has reasonable belief that any person has committed or intends to commit an offense under this act shall report the matter to a person in authority. A person who makes a report referred to in subclause 1 shall be afforded protection under the Whistleblowers Protection Act 2020. A person who A, does not comply with subclause 1, B, prevents, prohibits, dissuades, or hinders any person from making a report under this section, or C, victimizes a person who makes a report under subclause 1, commits an offense, and is liable on conviction to a fine not exceeding 72 currency points or imprisonment for 5 years, or to both fine and imprisonment. Subclause 4, in this section, a person in authority includes a member of the village local council, a member of a local government council, a resident district commissioner, a social welfare officer, or a police officer, a member of the Uganda Prison Services, a member of the Uganda People's, there is a repetition here of the Uganda, we cross of Uganda, the last of Uganda, People's Defense Force, or a member of any other law enforcement agency established by an act of parliament. Justification: to expand the people to whom a report of an offense can be made. Prohibit and punish persons who pervert justice by preventing the reporting of offenses or by victimizing persons who report offenses under the act.
Members, with the question that clause 11 be amended as proposed. Those in favor say aye, the contrary no. I have it.
Clause 11 as amended.
Put the question on the clause 11 as amended, do stand part of the bill. Those in favor say aye, the contrary no. Honorable Chair, new clause.
Insertion of new clause immediately after clause 11. Immediately after clause 11, insert the following new clauses. Extraterritorial jurisdiction. This act shall apply to offenses under this act committed outside Uganda, where A, the person against whom the offense is committed is a citizen of Uganda or is ordinarily resident in Uganda, or the perpetrator of the offense is a citizen of or resident in Uganda. Inspection of places where human sacrifice is likely to take place. 1, a person authorized by the minister may, after giving reasonable notice, inspect any house, building, or any place in which he or she has reasonable belief that an offense under this act is taking place or is likely to take place. 2, a person who carries out an inspection under subsection 1 shall prepare a report of the inspection. 3, where the report of the person referred to in subsection 1 indicates that there is need for immediate corrective action, the person shall give a copy of the report to the person or body to take the corrective action, including a member of the village local council, a member of a local government council, a resident district commissioner, a social welfare officer, a police officer, a member of the Uganda Prison Service, a member of the Uganda, again I'll cross out the second of the Uganda People's Defense Force, or a member of any other law enforcement agency established by an act of parliament. Consent of victim of an offense. The consent of the victim to human sacrifice shall not be a defense to a charge under this act. Report on the implementation of this act. The minister shall annually submit to Parliament a report on the implementation of this act. 2, the report referred to in subsection 1 shall contain information on A, the complaint made under the act, the investigation and prosecution of offenses as a result of the complaint and investigation. B, the incidents and occurrence of each of the offense prescribed in the act. C, the effectiveness of this act and government policy to deal with incidents of human sacrifice. D, the challenges faced in enforcing the act. And E, recommendation is on the challenges faced in implementing the act. Amendment of Act number 7 of 2009. The Prevention of Trafficking in Persons Act 2009 is amended by substituting for section 2, subsection paragraph G, the following. G, human sacrifice means the killing, mutilation, removal of a body organ, body part, or human tissue of a person, or the drawing of blood from a person for sale, or purposes of performing or furthering witchcraft, a ritual, or for any other unlawful purpose. In section 3, by inserting immediately subsection 1, the following. Subsection 1A, notwithstanding subsection 1A, where the person convicted of the offense of trafficking in person exploited the victim of the offense by carrying out human sacrifice, the convicted person shall, instead of the punishment prescribed in the subsection 1, be liable to suffer death if Roman 1, the convicted person is a parent, guardian, or person having authority or control over the victim of the offense. Or 2, offense of trafficking in persons resulted in the death of the victim. B, imprisonment for life where the offense results in grievous bodily harm to the victim. Or imprisonment for 10 years where the offense results in injury to the victim of the offense. Justification: for completeness, to criminalize persons who commit offenses prohibited under this act outside Uganda, where the victim of the offense or the perpetrator is a citizen of Uganda or ordinarily resident in Uganda. To make certain defenses irrelevant for a charge under this act. To empower the inspection of places where acts prohibited under this act may be performed. To require the minister to submit to Parliament annually reports on the implementation of this act. To harmonize the definition and punishment for the offense of human sacrifice in the Prevention of Trafficking in Persons Act 2009 with the amendment made to the bill.
The members, you have heard the proposals for the new clause. I now put the question. Yes. Unataka?
On inspection, a person authorized by the minister may, after giving reasonable notice, inspect any house, building, or any place in which he or she has reason to believe that an offense under this act is taking place or is likely to take place. I feel a little bit uncomfortable with authorized by the minister, because when such acts are taking place, there are emergencies, and I feel the authority of the minister can delay the inspection such that by the time they reach the place, the evidence has been tampered with. And this authorization, I think we should do away with it, such that the person, maybe a person who has authority, as long as they are with, maybe in company of police, they can inspect immediately. I beg to submit.
Honorable Chair.
Madam Chair, the intention of the committee was that the minister may give by secretary instrument a blanket, authority to give any person is to carry out this obligation.
The notice, like they have to give a notice to the person who is in charge of the premises that they are going to inspect. Yet somebody is committing a crime there, and then you tell them now police is coming also, and so is coming. I think something needs to be corrected here.
But how do you enter somebody's premises without notice? Okay. No article.
Thank you, Right Honorable Chair. I want to thank Honorable colleague for raising this concern. At the time we arrived at this position, Madam Chair, we knew how the people who hide under these places operate. We actually did a research, and of course, some people may be uncomfortable if we mention the word shrines. And of course, a shrine applies to all religions, including us, those of us who are Catholics. We have Namugongo shrine. We have other traditional believers who have shrines. But in those shrines, sometimes, Madam Chair, particularly the traditional ones, is where some of these grievous practices take place. And therefore, we're a bit careful in making these provisions. And when the committee made this submission, we are cognizant of the fact that, of course, you cannot enter somebody's private property without that person being served. And the fact that this notice will be served will mean that the place can be inspected. And the reason for inspection is to collect evidence. And our research indicates the kind of evidences that we'll be sourcing for, which have also been provided for in some of the sections in this bill. And therefore, the fear, I don't know, Chair, my position was.
Honorable Chaka's worry is that if you give notice, the element of surprise will not be there, and you'll have time to demobilize or move items. That's our worry.
Madam Chair. Madam Chair, the committee is proposing to delete after giving reasonable notice, since the Criminal Procedure Code Act gives the details and the circumstances under which a search can be conducted. So we would do the Criminal Procedure Code Act can come to aid in this respect.
Okay, honourable members, with the question that new clause be introduced as proposed, those in favor say aye, the contrary no. Ayes have it.
Clause 12.
Clause 12, Honourable Chair, you had something? On 12?
Clause 12, regulations. Clause 12 is amended by inserting immediately after subclause 1 the following. The regulation is made under subsection 1 shall be laid in Parliament for information. Justification to require the laying of regulations in Parliament for information.
Members, I put the question that clause 12 be amended as proposed. Those in favor say aye, the contrary no.
Clause 12 as amended.
Question is that clause 12 as amended do stand part of the bill. Those in favor say aye, the contrary no.
Clause 13.
With the question that clause 13 do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
The schedule.
With the question that the schedule do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 1.
Clause 1, Honorable Chair. I think there are no new interpretation, no new definitions.
Interpretation. Clause 1 is amended by A, substituting for the definition of the phrase human sacrifice the following. Human sacrifice means the killing, mutilation, removal of a body organ or body part or human tissue of a person, or the drawing of blood from a person for sale or purposes of performing or furthering witchcraft, a ritual, or for any other unlawful purpose. B, inserting the following new definitions appropriately. Imprisonment for life means imprisonment for the natural life of a person. Mutilation means the unlawful and partial or total removal of a body part of a person. Ritual means a religious, traditional, or cultural ceremony consisting of a series of actions performed for satisfying a belief. Witchcraft includes sorcery, enchantment, bewitching, the use of instruments of witchcraft, the purported exercise of any occult power, or the purported possession of any occult knowledge. Justification, to expand the definition of the phrase human sacrifice by including the drawing of blood from a person and the removal of human tissues. In definition of the phrase human sacrifice, to remove an ambiguous phrase harmful human practices, which was incapable of exact definition, and replace it with the unlawful purpose. For clarity, to define the words mutilation, life imprisonment, and witchcraft.
Members, to the question that clause 1 be amended as proposed, those in favor say aye, the contrary no. Ayes have it.
Clause 1 as amended.
Question that clause 1 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
The title.
To the question that the title do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Motion for the House to resume.
End of article.
Thank you, Right Honorable Chair. I beg to move that the House do resume and the Committee of the Whole House reports thereto.
Now, members, the questions that the House do resume and the Committee of the Whole House do report thereto. Those in favor say aye, the contrary no. Aye.
A report from the Committee of the Whole House.
End of article.
Right Honorable Speaker, I beg to report that the Committee of the Whole House has considered the bill entitled The Prevention and Prohibition of Human Sacrifice Bill 2020 and has passed it with various amendments and deleted clause 8 and inserted a number of new clauses. I beg to move.
Motion for the adoption of the report from the Committee of the Whole House.
End of article.
Right Honorable Speaker, I beg to move that the report of the Committee of the Whole House is adopted.
Now, members, the question is that the report of the Committee of the Whole House be adopted. Those in favor say aye, the contrary no. Ayes have it.
Bills third reading.
End of article.
Right Honorable Speaker, I beg to move that the bill entitled The Prevention and Prohibition of Human Sacrifice 2020 is read a third time and do pass.
Now, members, the question is that the bill entitled The Prevention and Prohibition of Human Sacrifice Bill 2020 be read for the third time and do pass. Those in favor say aye, the contrary no. Ayes have it.
A bill for an act entitled The Prevention and Prohibition of Human Sacrifice Act 2021.
Title settled and bill passes.
Item.
Madam Chair, Madam Speaker.
Yes, Honorable Chip.
Thank you, Right Honorable Speaker. Allow me to use this opportunity to thank you for enabling us to fast track the passing of this bill. Madam Speaker, allow me also to use this opportunity to thank honorable colleagues for standing with me in processing this bill, undertaking the various consultations and compiling the reports and eventually presenting this bill for first reading and today seeing it being passed. Madam Speaker, you will allow me to appreciate the following people. First and foremost, allow me to thank the Minister of Justice and Constitutional Affairs for delegating an officer from the first Parliamentary Council with whom I've been working on this bill. If you remember very well, when I moved the motion seeking leave, the Prime Minister did promise to support this bill, and indeed he did that by instructing the Minister for Justice and Constitutional Affairs to delegate a competent person in the names of Paul Okrig. Madam Speaker, the judiciary also supported me in this process. We had interaction with the Justice Yaseni Nyanzi, who shared with us his personal experience of facing difficulties in prosecuting cases involving human sacrifice. And it's part of his experience that informed this bill that now will become an act. With other judges, Madam Speaker, who shared their experiences. Madam Speaker, allow me also to thank the Uganda Law Reform Commission and the society who shared with us their expertise and experiences. Madam Speaker, we worked together with Uganda Parliamentary Forum for Children, whose mission, whose motto is children first. Majority of the victims of human sacrifice have been children. And this parliament today has done the noble duty of passing a law that will protect the future of the human beings in this country. We have worked together with the civil society organizations in the names of World Vision International, Children on the Edge, CHAMPC Child Care Ministries. Madam Speaker, Children on the Edge is an organization that's international, based in the UK, that have followed the press reports of cases of human sacrifice. And today, as we are passing this bill, we have a representative in the name of Anne Ipa, who is right there in the technical bench. She has come to witness the final passing of this bill, and we'd like to thank everybody who has helped in processing this bill, and the Committee of Legal and Parliamentary Affairs for tirelessly working to ensure that today this bill is passed. This is my gift. This is the gift to children of Uganda. This is the gift to everybody who has suffered the pain of human sacrifice in this country. I thank you, Right Honorable Speaker, for God and my country.
Thank you, Honorable Atiku. Does the Chair of Legal wish to say something?
Thank you, Right Honorable Speaker and colleagues. I would like to thank the mover of the bill, now enacted into law, Honorable Bernard Atiku, for the effort he put in from the time this bill was referred to our committee. He has been cooperative, and he has provided any information the committee would require of him. I want to take this opportunity to thank all the members of the Legal and Parliamentary Affairs Committee who dedicated all their time and effort to ensure that this bill is processed. And Madam Speaker, allow me to thank the whole House for the time it has devoted to this bill and the due debate that he has accorded to our report and eventually enacting the bill into law. This is a gift that Uganda has got because child sacrifice is on the rise, and indeed it needed a law of this nature, aware of the fact that the Constitution is quite arrived the fact that life shouldn't be taken away just at the whims of those who want to benefit and satisfy their own interests at the expense of the victims and the dependents of those that lose their lives as a result of sacrifice. I thank you. I thank everyone.
Thank you very much, the Chair of Legal and Parliamentary. I think I want to add the thanks of this House to your committee. Between you and the Committee on Finance, I think your committee has borne the biggest burden of bills before this House. So really want to thank you for the work you've done. But more importantly, on a number of occasions, when children's delegations come to visit me at Parliament, many times they have asked me, where is justice focused here? That young boy who was sacrificed in the Katoka Juvi case, as you remember. I think today we can answer that question and say that Parliament has not provided an opportunity, an avenue for justice for Kasrie and other victims like him. So thank you so much, honourable members, for the work you've done. Now I'd like to suspend the House for 1 hour so that we can resume at 3 p.m. House suspended.